Wait lang. Start na.
Good morning, attorney, and good morning, classmates. Good morning. We are Group 2, and everyone already knows who I am. So I am Jerison Cristosena. Most of you call me JT. And we are Group 2, and we're going to report about Title 6, Title 7, and Title 8 of the Family Code. So that will be adoption and support from Articles 183 to 208. So the outline of our report is first adoption, and we're going to tackle the important questions about adoption, such as what is adoption, background laws on adoption, who may adopt, who may be adopted, requirements, effects, decision, and inter-country adoption. Next is support. We will talk about, again, important concepts about support, from grounds to properties, rights to pendente, order, amount, demandability, characteristics, and up until contractual support. But wait, there is more. So we are not only going to discuss these things to you, we also want you to join us in having fun over this particular activity. So our group has prepared prizes for everyone. So we would like to encourage you to listen so that you will be able to win. So this, ang ating mga minor prize po, we have playing cards from Pagcor. Yes. We have hello. Goodbye. Again, we have para makatipid kayo sa tubig, sa baba, sa fountain na lang kukuha using tumbler. Diba? And from Pidea, planner. And ang ating grand prize, this limited edition mug from the Office of the President. So, if you guys want to have these prizes, listen to Group 2 and enjoy the show. So I will now turn you over to the first reporter, and you may call him Jay, but I call him Idol. Pasok.
Good morning, everyone. My name is Jason. So I'll be discussing, or I'll give you a short overview about adoption and the laws governing the adoption. So to give you insight, or just to define the adoption, it is a juridical act, a proceeding in rem which creates between two persons a relationship similar to that which results from legitimate paternity or filiation. So that means that you're just legally taking someone else's child and you treat him or her as your own, and that child or the foster kid would have a similar or similar treatment as that of legitimate child. So only an adoption made through the court or in pursuance with the procedure laid down under Rule 99 of Rules of Court is valid in this jurisdiction. So just to give legitimate treatment to a foster kid, then there should be a judicial declaration that that the foster kid is adopted. So what are the laws governing the adoption? There are three. That is Family Code, and then Domestic Adoption of 1998, and Inter-Country Adoption Act of 1995. So I'm just going to give you a short background or overview on these laws, because that will be expounded more in the next slides by my team members. So Domestic Adoption Act of 1998. So this law governs the domestic adoption of Filipino children, whether the adopter is a citizen of the Philippines or an alien. So if a citizen of the Philippines or an alien can adopt a child, however, for an alien, he should be residing here in the Philippines prior to the adoption or filing of the petition for 3 years. And then for the Inter-Country Adoption Act of 1995, this law governs the adoption of a Filipino child in a foreign country by a person who may not even be qualified to adopt under the Family Code or the DAA. So that means that a foreigner or a Filipino currently or and permanently residing in the other country can adopt a Filipino child in reference or in accordance with Inter-Country Adoption Act of 1995. So that's it for me.
So hi, I'm Elita Esquina and I will be here to discuss who are qualified to adopt under domestic adoption. So domestic adoption, as mentioned earlier, is governed by the Domestic Adoption Act of 1998 and the provisions of Title VII of the Family Code, as far as it has not been amended by the Domestic Adoption Act. So an adoption is said to be domestic when it has took place from the time of the filing of the application of the petition for adoption, from the time of the issuance of the adoption decree when it has taken place in the Philippines. So, generally, a citizen of the Philippines or an alien in the domestic adoption may adopt as long as they are qualified under the Domestic Adoption Act. So, what are these qualifications? So Article 183 to 186 of the Family Code provides the qualifications of adoption under domestic adoptions. So generally, a Filipino citizen, an alien, a guardian, or spouses by joint adoption may adopt under domestic adoption. So we will be discussing first the qualifications for the Filipino citizen. So for a Filipino citizen to be qualified to be an adopter, they must be of legal age. So this means that a minor is not allowed to be an adopter. They must also be in possession of full civil capacity and legal rights, which means that insane, imbecile, deaf-mute, and persons suffering from civil interdiction are not allowed to be an adopter. They also need to be of good moral character, has not been convicted of any crime involving moral turpitude, emotionally and psychologically capable of caring for children, in a position to support and care for their children in keeping with the needs of the family. And in addition to the legal age qualification mentioned earlier, they must be at least 16 years older than the adoptee, except when the adopter is the biological parent of the adoptee or the adopter is the spouse of the adoptee's parent. And lastly, they must be a permanent resident of the Philippines. So under the Civil Code of the Philippines, one who already has a legitimated child, acknowledged natural child, or natural children by legal fictions are not allowed to adopt another children. For the purpose that this will not only create conflict in families, but it would also materially diminish or affect the existing successional rights of the children. However, fortunately, this has not been carried forward in the Domestic Adoption Act and in the Family Code. As I mentioned earlier, aliens are also qualified to adopt, and generally, they have the same qualification. They need the same qualifications for Filipino nationals, but with certain additions as follows. The country of the alien must have diplomatic relations with the Republic of the Philippines. Their government must allow the adoptee to enter their country as their adopted child. They must have been living in the Philippines for at least 3 continuous years prior to the filing of the application for adoption and maintain such residence until the adoption decree is obtained. And they must have been certified by their diplomatic or consular office or any appropriate government agency that they have the legal capacity to adopt in their country. So the last 2 qualifications for the aliens may be waived if they are a former Filipino citizen and they seek to adopt a relative within the 4th degree of consanguinity or affinity, or when they seek to adopt the legitimate son or daughter of their Filipino spouse. And lastly, when they are married to a Filipino citizen and they seek to adopt jointly with their spouse a relative within the fourth degree of consanguinity and or affinity of their Filipino spouse. And next, guardians can also adopt, but only after the termination of their guardianship and the clearance of their financial accountabilities. So generally, husband and wife are required to jointly adopt. In the case of the petition for adoption of Michelle Lim and Michael Lim, the court ruled that the requirement of the joint adoption of husband and wife are mandatory. And this is in consonance with the concept of joint parental authority and to ensure the harmony between the husband and wife. So generally, they are required to jointly adopt. But there will be certain exceptions when the spouse seeks to adopt the legitimate son or daughter of the other, or when the spouse seeks to adopt her own legitimate son or daughter, provided that the other spouse has signified their consent. So in the case of Castro versus Gregorio, the court explained that in order for this kind of adoption to be valid, the consent of the other spouse is required together with the personal service of someone to be effected to the other spouse and to all the legitimate children to ensure that all their successional rights are protected. It is also to be noted that the law allows the exception for the adoption of the spouse's own illegitimate son or daughter, and does not provide for the exception if the spouse seeks to adopt the illegitimate child of the other spouse. And lastly, they are not allowed to jointly adopt when they are legally separated from each other.
So, good morning everyone. I'm Jeffrey Angelo Severino and I'll be reporting about those who may be adopted. Okay. So first, under the provisions of the Domestic Adoption Act, as amended by Republic Act number 9523, or the act requiring the certification of DSWD or Department of Social Welfare and Development for a child to be declared adoptable. So under those provisions and Republic Act, only the following may be adopted. First, that the adoptee must be certified by the DSWD that he or she is legally available for adoption after fact of abandonment or neglect has been proven or has been voluntarily committed by his or her parents or legal guardian at any age, but is unable to fully take care of or nor protect herself. So it simply states that legally available for adoption after being certified by the agency assigned with the implementation of the policy of the state to assist and protect those children who are abandoned, neglected, and surrendered. And that agency of the government is the DSWD. We have to stress the fact that the provision stated that there needs to be an establishment of facts that the guardian is the legal guardian of the adoptee. You cannot adopt someone na sinurrender lang basta-basta without establishment of the fact na siya yung legal guardian. Kasi baka mamaya napulot lang niya yun tapos kunin niyo, ganun. Hindi pwede yun. Okay? So, yung sinasabing certificate dyan, it only applies to surrendered, abandoned, or neglected children. Again, surrendered, abandoned, or neglected children, which we will define later kasi may kasama sa slides namin yung definition of terms. All of those are encompassing of the Republic Act number 9523. Question. Can the certification be used as a primary evidence that the child is legally available for an inter-country adoption? The answer is yes. Yes. As provided in the RA number 8043, which is the Inter-Country Adoption Act, it would suffice as the legal basis of document or proof na pwede siyang adopt inter-country related. So second, pwedeng ma-adopt yung legitimate son or daughter of one spouse by the other spouse. So I'll give an example. Let's say A had a son with his first wife who unfortunately died. He then remarries B. So again, A may asawa, namatay. Which following that, nagpakasal ulit kay B. B now wants to be, given that scenario, mayroong anak si A with his first wife, si C. Okay? B now wants to be the legal parent of the son of A, which is C. Adoptable ba si C by B? The answer is yes, adoptable if there is an establishment of a fact that A and B are considered each other's spouse. So kapag wala namang legal impediment, nagsama sila, may anak sa unang asawa si A, pwedeng i-adopt nung pangalawang asawa niya legally yung anak niya. Okay? A child by nature of the adopter's spouse may be adopted even if he or she is of legal age. So kahit 18 na siya pataas, na may discretion na siya kung gusto niya magpa-ampon or hindi, pwede under the law. And next is an illegitimate son or daughter by a qualified adopter to improve his or her status to that of legitimacy. So ito yung basis or sole purpose of adoption is to improve the status of legitimacy ng bata. So let's say for instance, balikan natin yung gamitin pa rin natin yung example kanina sa first example ko sa letter B. Let's say in our previous example that A's wife did not die. So walang namatay, kasal pa rin si A at B. But C is a child by nature of B, meaning si C, illegitimate son. Anak siya sa labas ni A kay B. Si B yung kabit, no offense, kabit. Okay? Again, C is a child by nature of B, meaning an illegitimate son of A with B. First instance, A wants to legally adopt C to make him a legitimate child. Dahil anak niya sa labas, gusto niyang ampunin ngayon para maging legal na anak niya, maging legitimate son. Pwede ba yun? Yes, affirmative, pwede. Okay. As long as the wife of A signifies her consent. As long as pinayagan nung legal na asawa niya na ampunin siya, pwede. Kailangan may consent. Okay. Although, kahit payagan niya, she does not need to join in the adoption. Pwedeng ampunin lang nung asawa niya yung anak. Pero sa batas, hindi ino-honor na anak din niya yung anak sa labas. Legitimate son lang siya ngayon nung asawa niya. Okay? Now, another instance of the same example, A's wife wants to adopt C to make him their legitimate son. Ngayon, gusto na niya nung asawa ni A maging legitimate son nila pareho yung anak nung asawa niya sa labas, which is C. Pwede ba yun? Again, affirmative, pwede. But the law requires both spouses to jointly adopt C. Hindi pwedeng yung asawa nung may anak sa labas lang yung aampon dun sa anak. Kailangan, pag ganun yung instance, dalawa sila na mag-a-adopt jointly dun sa anak sa labas. Okay? So letter D, a person of legal age if prior to the adoption, said person has been consistently considered and treated by the adopters as his or her own child since minority. We have to stress dyan yung last part na since minority. Okay, kasi legal age na siya. Okay? I'll give you an example ulit na wala na doon kay A, B, and C. Ibang letters na. Okay. So, X and Y wants to adopt the son of their maid who passed away, which is C. Okay, so X and Y, married, mag-asawa. Ngayon, may katulong sila na mabait siguro, na may anak. si Z. Ngayon, namatay na yung katulong nila. Pero kinupkup nila si Z bilang anak nila without the proper or the formal adoption processes. Now, pwede ba nilang ampunin legally si Z? Yes, if since minority, bago siya naging of legal age, minor pa lang siya, inalagaan na nila, entrenato na siyang bilang tunay na anak. Okay? So yes, as long as Z is of legal age and it has been established that they have been treating Z as their own child since minority. Again, stress ko ng mas malalim, kailangan prior to the adoption, yung pag-alaga sa kanya ng mabuti or pagmamahal sa kanya bilang tunay na anak. Kailangan prior to the filing of the adoption, inalagaan at minahal na siya. Hindi pwedeng inalila siya, ginawang katulong, tapos for whatever beneficial reasons gusto nilang ampunin. For example, ginawa nilang katulong si Z. Tapos pinasweldo nila, sweldo niya lang 20. Yung 20 na yung tinaya niya sa loto, nanalo siyang loto, bigla gusto nilang ampunin si Z para may claim sila sa price of the winnings ng loto. Okay? Hindi pwede yun. Kailangan, before pa lang siya naging legal age and before pa na-file yung adoption, trinato na siya bilang tunay na anak. Yes po.
Walang specific period na at least 2 months, 1 year, dapat
Wala. As long as before the filing of the adoption. Bago siya maging legal age, dapat minor siya. Then pagka legal age niya, doon magpa-file ng adoption. Gets? Diba? Understood? Okay. So, next na po. So, a child whose adoption has been previously rescinded. So, yung term dyan is yung rescinded. It means to cancel or take back kung whatever process man yung ng adoption yung nagawa. So, you may adopt those children na parang na-cancel out yung pag-adopt sa kanila for whatever reasons. Of course, being the humane that we are, kailangan may chance pa rin silang ma-adopt ulit kung gusto nila. Diba? And F, a child whose biological or adoptive parents has died. So, diyan, napakasimple, a child whose biological or adoptive parents has died, namatay yung parehong parents niya, pwede siyang ma-adopt. Pero, ito yung tandaan nyo, no adoption proceedings shall be initiated within 6 months from the time of death of said parents. So, pagkamatay ng parents niya, kailangan after 6 months pa lang ng pagkamatay nila, doon ka mag-file ng adoption. Not stated, pero I think for respect sa namatay na Okay. Take note that our laws do not prohibit relatives either by blood or affinity from adopting one another. So, for example, tita ko, namatay yung parents ko, pwede niya akong i-adopt and be legally anak niya, be a legitimate son of hers. Okay? Walang prohibition yung laws natin regarding that. So now, tulad yung mga sinabi ko kanina, mayroong mga situations that are requiring consent from one person to another para ma-legally adopt yung isang bata. The requirement of consent. The written consent of the following to the adoption is required. Ito yung mga sasabihin ko. But first, i-classify natin sila. Dalawa lang naman eh. Consent of biological parents and consent of legitimate children. So whatever dyan, mamaya sasabihin ko lang kung saan siya mag-fall doon. First, the adoptee if 10 years of age or over. So yun, nasa yung sa ina-adopt mo na mismo. Pag 10 years old na siya pataas, kailangan may consent na pumapayag siyang sampunin mo siya. Okay? Hindi pwede yung ayaw naman ng bata tapos pipilit mong sampunin siya. Second, the biological parents of the child, if known, or the legal guardian or the proper government instrumentality which has legal custody of the child. Again, as stated a while ago, sino yung proper government instrumentality which has legal custody of the child? DSWD. Okay? So if buhay and kilala yung parents nung i-adopt mo, kailangan ng consent nila bago mo siya ma-adopt. again, very self-explanatory as respect dun sa biological parents talaga. Okay? And next, the legitimate and adopted sons or daughters, 10 years of age or over of the adopters and adopted, if any. Yung mga legitimate and yung mga naampon na ng pamilya, ng mga anak, kailangan may consent din sila pag mag-aampon ka ulit. Kasi baka, nagigets nyo yun, parang baka wala naman ng capacity na magpalaki pa ng bata tapos aampunin pa. Kailangan may consent yung family, mapag-usapan na tatanggapin siya sa pamilya. Ganun. Okay? Next, the illegitimate sons and daughters, 10 years of age or over, of the adopter if living with said adopter and the latter spouse if any. So again, parang ganun din, kahit anak sa labas, syempre masakit nga naman, anak na ako sa labas tapos may aampunin kang iba na gagawin mong legitimate child mo. Akong illegitimate, di mo ako gagawin illegitimate, di ba? So kailangan ng consent niya kung mag-aampon ka ng iba.
Kita.
And again, the adopter and the latter spouse if any. So kung may spouse din yung mag-a-adopt, kailangan din ng consent niya. Of course. Kaya nag-uusap dapat ang mag-asawa, di ba? Okay. Communication skills, di ba? Okay, so number 5, the spouse, if any, of the persons adopting or to be adopted. Again, gano'n nga, the spouse nung aampunin. Okay? Kunwari, of legal age na siya, pero gusto mo pa rin siyang gawing legitimate child, may asawa na siya, kailangan mo ng consent dun sa asawa niya na aampunin mo siya. Kasi it happens na, for example, 30 years old na, pero for formality gusto mong i-adopt and gawing legitimate child. Siyempre, by the age of 30, yung most likely may asawa na yun, which is the nature of our life, di ba? So, kung may asawa na yung aampunin mo, kailangan mo ng consent ng asawa niya. Okay? Now we move on to the adoption procedure, which is yung sa domestic part lang. Of course, the coverage of the RA number 9523. Adoption has 2 stages, purely administrative and judicial proceedings. So ang i-discuss ko lang is the administrative part. Okay? So first is the coverage of the Republic Act 9523, or again, the establishment of the fact that the adoptee is legally available. Tulad yung mga sinabi ko kanina kung paano siya magiging legally available for adoption. That requires submission of pertinent documents proving the abandonment or neglect of the child. So documents lang that would suffice for proof na yung bata is legally available for that's one part of the steps. Okay. Number 2, I think it would follow the issuance of DSWD certification. So parang step by step lang ang administrative proceedings yung sinasabi ko. This would follow the issuance of DSWD certifications if there are no anomalies found during the filing of the proceedings. So, check lang kung tama yung pagpa-file mo. And then, it would lead to the matters regarding the legality of the adoptee. So, kung yung mga sinabi kanina sa mga dun sa term na who may be adopted, na follow naman, walang problema. It would push through with the adoption process. Although it must be considered that the child or the adoptee must be considered deserted, naiwan, for at least 3 continuous months. Again, hindi siya 3 months. 3 continuous months. Kailangan tuloy-tuloy. Okay? And neglect of basic needs have been deliberately unattended or inadequately attended. I-distinguish natin yun. Deliberately unattended, wala ka talagang binigay. As in, wala. Pinabayaan mo. Inadequately attended, although may efforts kang binigay, of course, may mga instances na hindi talaga enough yung mga ginagawa natin para sa mga tao. Again, it should be filed within a period of 3 continuous months. Okay? Neglect may occur in 2 ways. So yung sinasabi ko na kaninang neglect, it may occur in 2 ways. First, the manifestation of malnourishment, ill-clad, and without proper shelter. So, malalaman mong na-neglect yung tao, yung bata na i-adopt mo, First, kapag mukha siyang malnourished, so very self-explanatory, alam naman natin ano yung malnourishment. Diba? Pangalawa, ill-clad. Everyone understands ill-clad. Ill-clad meaning being poorly dressed. So kapag nakita mo mukha siyang hindi kaaya-aya, mukhang pinabayaan talaga na basahan yung damit, may manifestations of being neglected. Okay? And without proper shelter. So kung pinatulog siya sa bahay ng aso, gano'n, that's so harsh. Ganun, diba? Okay. So that's one. Manifestations of malnourishment, ill-clad and without proper shelter. Next is kung saan pwede mag-occur ang neglect is the emotional neglect. So hindi lang yung sa physical aspect, meron tayong emotional neglect. First, maltreatment. Pag hindi maganda yung treatment sa kanya dun sa kung nasan man siya. The term na napapanood nyo sa yung minaltrato. Kaya maltreatment. Okay. So, first yun, maltreatment, being raped, seduced, exploited, overworked, or pinagtatrabaho sa lugar or sa any setting na not conducive for good health. So kung pinagtatrabaho siya sa kung saan man napuno ng ammonia, ganun, or whatever, na hindi conducive for good health, syempre, meron emotional neglect dun. One example is to beg on the streets. Kapag, di ba, alam naman natin yung streets natin hindi siya conducive for good health dahil sa pollution. So kapag pinaglimos mo yung bata, that's considered an emotional neglect. Or hindi lang limited sa streets, any other public places. Okay? Another one, or the last one, para mapasakop sa emotional neglect is being exposed to moral danger. Kapag yung bata in-expose mo deliberately sa mga bagay na hindi dapat para sa bata, for example, sa casino, which rampant ang gambling, of course, and sa beer house na may prostitution, doon mo siya pinapatira, may moral damages, may moral danger doon, which could lead to emotional neglect. Or in any form of vices, of course, sa drugs. Kapag lumaki siya sa tabi mo habang nagda-drugs ka, mayroong emotional neglect doon. Okay? So, meron tayong tinatawag sa part pa ng administrative processes of filing sa adoption is the petition. Wala pa rin dyan. Okay. So, the petition is madami siyang parts. There are actually 10. I don't want to bore you. So sabihin ko na lang yung mga essentials. First is the substance of the petition. So kailangan meritus yung petition mo kung bakit ka nag-adopt ng bata. Kailangan nakatouch dun yung social case study made by the DSWD and proof that there were efforts made to locate the parents nung bata. Okay? Yung proof of efforts made to locate the child, meron pang parang qualifications. Pwedeng written certification from a local or national radio television station that the case was aired on 3 different occasions. So kailangan 3 beses pinalabas sa TV or pinarinig sa radyo. Pangalawa, publication in 1 newspaper of regular circulation. Pangatlo, police barangay report certificate from the locality where the child is found. In which the report is issued by the tracing report is issued by the PNRC or Philippine National Red Cross and National Headquarters Social Service Division. Madami pang pero masyado na madaming time na yun. Okay. So, meron pa, who can file the petition, kasama pa sa petition. It's stated in your book, napaka self-explanatory and napaka vivid na doon kung sino yung pwedeng mag-file ng petition. It's the page 864 of the book. If wala kayong book, pwede niya kami sa akin. Okay, and when to file the petition, after but not less than 3 continuous months from the time of abandonment, neglect, or dependence of a child. Where to file the petition, the regional office of the SWD, from where the child was found. In case that the child transferred outside the region where the child was found, very vivid ulit, nasa book. Hindi ko, kasi last 5 minutes na topic. Topmost part of, the topmost paragraph sa page 865. And then, meron tinatawag na review of petition. Kumbaga, lahat naman tayo, gets na natin yung notion na yun, na kapag nag-file tayo petition, it's always subject for review kung tama ba yung nasa petition mo. Okay? And posting of petition, ito yung may processes din doon na kapag veritus yung petition, kapag nalaman or na-found na sufficient siya, enough, kailangan i-post yun. Tulad yung napag-aralan natin sa kay Sir Attorney Tinto Cervantes, natutunan ko sa kanya. Di ba tulad sa marriage, kapag kukuha ka ng marriage license, kailangan ma-post siya dun sa it's the same way with the petition, para aware yung society kung nasan yung bata na available siya for adoption and may nag-a-adopt sa kanya, may gusto mag-adopt sa kanya. Okay? It should be in a conspicuous place, meaning nakaka-attract ng attention yung lugar. Hindi pwedeng pinost mo pero nakatago naman, nasa likod ng poste, ganun. Hindi pwedeng ganun. Okay? Why do we need to post? It's the same notion or idea of why do we need to post the marriage license. Para if merong gustong mag-appeal, makikita niya na, eto, hindi niyo pwedeng ampunin to kasi anak ko to. Parang ganun. Okay? Sabihin ko na lang the transmittal of the recommendation kasi kapag yung petition, okay na, may recommendation yung DSWD Central Office. Kailangan ay yung regional head ng DSWD kailangan transmit niya yun, yung recommendation sa DSWD Central Office. Then, declaration of the availability of adoption, formality lang yan, na declare siyang available. Although the certification, if found veritus, shall be filed within 7 working days from the receipt of the recommendation. The certification is the sole basis for the immediate issuance by the local civil registrar of a founding certificate. A founding certificate is to be transmitted to the National Statistics Office within 7 working days. And the issuance of certificate of founding issued by the local civil registrar of the municipal or city within 5 working days and to be transmitted in the NSO within 7 working days. Nasa book din yun, madali lang naman natin mababasa yun. And take note that a copy of the child's profile should be attached to the certificate. And lastly, yung sinabi ko na kanina, bakit kailangan natin i-post para merong way para sa mga mag-a-appeal. The appeal is the decision of the secretary shall be appealable to the Court of Appeals, of course, within 5 days from the receipt of the same petitioner. So kailangan yung same petitioner yung mag-a-appeal kapag na-deny siya, yung petition niya. Okay? So ito yung sinasabi yung definition of terms. Yung next reporter na lang po yung mag-define since madami na ako nasabi. The petition shall be granted by the regional director or his or her authorized representative, and when the DSWD deemed the petition to be satisfactory. Magiging satisfactory lang yung petition of adoption when the parents or legal guardian, tulad na sabi ko kanina, are in the position to be adequately provide the basic needs. So magiging legal adopter ka lang kung ma-prove mo sa court or kung saan sa agency ng DSWD na may kakayahan kang i-provide yung mga bagay na wala siya. Okay? So that's it po. Thank you for listening.
So, I'll be presenting judicial proceedings. My name is Gabriel Venancio Nicomica. So, what differentiates administrative proceedings from judicial proceedings is this is a lengthier process. Essentially, the process is the same with administrative proceedings. It's just the judicial proceedings involves the Office of the Solicitor General on acting on behalf of the state. So, first, we'll discuss the jurisdiction of venue. You may file an adoption proceeding within the family court that has exclusive jurisdiction over the area where the child currently lives. The question is, what if there is no family court where the child lives? You file the petition to the nearest RTC possible. Next, nature of adoption proceedings is in rem. means no court may entertain unless it has jurisdiction, not only over the subject matter of the case, but over the parties, but also over the personal status of the person to be adopted and not adopting parents. Notice is made through publication in the newspaper general circulation, so that if someone opposes the petition, they may file the corresponding memorandum before the court. Contents, basically, this was explained by my group mate. The only difference is if the doctor's corner, there are additional requirements such as his country was subject to diplomatic relations with the Philippines. He has been certified by its diplomatic mission or any appropriate government agency to have legal capacity to adopt in his country, and his country allows the adopted child to enter and reside there permanently. And that he has been living in the Philippines for 3 consecutive years at the place where the petition is filed. So this is also self-explanatory na. This has been explained a while ago. I'll go to the more important details. Petitions, of course. There must be relevant facts, the first name, surname, names, age, and residence of the adoptee, as shown by his available records of birth, baptismal, or founding certificate, also school records. The adoptee is not disqualified by law to be adopted. The probable value and character of the estate of the adoptee, that the first name, surname, or names by which the adoptee is to be known and registered in the civil registry once the petition is granted. A certification of non-forum shopping shall also be included pursuant to Section 5, Rule 7 of the Rules of Civil Procedure. The most important one is the certification for non-forum shopping, because that's the part that states that he did not file any similar action before any other trial court in the Philippines. Because if it's found that he filed another similar action within the trial court, will have a corresponding penalty. Simulation of birth. Just to remember, the stamping of civil registry records, making it appear that a certain child was born to a person who is not his or her biological mother, causing such child to lose its status. So essentially, you're falsifying someone's birth records. The person who simulated the records has penalty except prior to the effectivity of the DAA. It shall not be punished if it was made in the best interest of the child, if the application for action shall be filed within 5 years of the effectivity of the act, and such person complies with such procedures specified in Article 4 of the DA and other requirements set in the SWD. Adoption of a founding, so it's essentially the same, state of facts, where the founding was found, names of the parents, if known, or adopted parents, and the residents. If the child has no known living parents, then the name and residence of the guardian who found them, if any. And the name of the duly licensed child placement agency or individual under whose care the child is in custody. Department, child placement agency, check caring agency is authorized to give its consent. Annexes to the petition. First, this is the most important thing, because if this is lacking, the petition will be dismissed without prejudice. First is the certification issued by the DSWD, records available, affidavit of consent by the guardian or parent for its adoption, child study report on the adoptee and his biological parents prepared by social work of the court or to the SWD or any other competent agency. A home study report was prepared by social workers. The degree of annulment, mandatory legal separation of the adopter, if there is. So order of hearing. So of course, petition. You will put in the petition the registered name of the adoptee, the purpose, the complete name of the adoptee if it so the date and place of the hearing shall be set 6 months within the date of issuance of the order, and there will be a posting of the petition in conspicuous places, and it shall be published in a newspaper journal circulation. So usually you post the petition in the city hall, in the post office, in the place where the adoptee is residing, and in the bulletin board of the courts. Afterwards, the court solution order to the social worker to conduct such investigation. Copies of the petition should also be furnished to the OSG, the city or provincial prosecutor, the DSWD, and the biological courts, and of course the council. Why is OSG furnished? Because it intervenes, because it is in the best welfare of the child. And OSG seeks, and the OSG seeks. So, child study reports, it shall be made by a court social worker. No hearing will be set unless a licensed social worker has submitted a report and recommendations on matter to the court. So again, if there's no report, there will be no hearing. Social workers shall verify with the local civil register the details about the real identity of the adoptee. If the person is not registered, he or she shall take responsibility of the registration by the use of late registration papers. Social workers shall also determine that the child is legally available for adoption, and after analysis, the social worker finds grounds to deny petition, he or she shall make the proper recommendation to the court. So as you see, adoption, the judicial proceeding is much more complicated than administrative proceedings. So hearing and supervisory custody. Of course, the petition adoptee must appear before the judge of the court on the date set for hearing together with their counsels. The Office of the Solicitor General, through the city or provincial prosecutor deputy, shall appear on behalf of the state. Then, the court will verify with the social worker and determine whether the biological parent has been properly counseled about making hasty decisions. Must make sure that all measures to strengthen the family has been exhausted, and ascertain that if any prolonged stay in his own home will be inimical to the child's welfare interest, no adoption decree shall be issued until the adopters have been given by the court a supervised child custody for a period of at least 6 months, in which the parties are expected to adjust psychologically and emotionally in order for their bonding relationship to be established. Now, this 6-month period is not absolute, as the court may motu proprio, or translation its own purpose, or unknown shall reduce the period if it's for the best interest, the court will determine when. However, if aliens will adopt, you must complete the 6-month period. The social worker shall submit a report to the court after 2 weeks of termination of the proceedings. Next, degree of adoption, the most important thing is, if this is granted, first thing that will be included is the name by which the child will be known. So if his surname will be changed from, let's say, Hernandez to De La Cruz, or his name will be changed, it shall also be included there. The marriage clerk of court will issue a certificate of finality once the reglementary period of priority expires, which is 15 days. The adopter will submit a certified true copy of the certificate of adoption together with the certificate of finality to the LCR. LCR of the place shall annotate the adoptee's original certificate within 30 days of receipt of the finality. The new certificate of birth, which shall not bear any relation to the new certificate. The original birth cert, the previous one that was not unpaid, shall be sealed within the records of the LCR. It shall not be opened until a court order says so. And of course, the LCR shall submit to the court the compliance with the requirements of the court. So, ayun. Time for the floor is yours.
Games.
Thank you, Gab. So since we have already talked about background, concept, about adoption, who may adopt, who may be adopted, and let's now move on to the effects of adoption. So the effects of adoption are expressly provided in Article 188 of the Family Code. So I will not read it anymore because we're running out of time. So please just refer to your books. But essentially, it says that the effects of adoption are, first, the transfer of parental authority, legitimacy, and succession. So I will try to discuss them one by one. So first is the transfer of parental authority. So the general rule is, parental authority of the biological parents over the adopted ceases and is transferred to the adopter. So this means that the legal tie between the adopted and his or her biological parents will be severed, and that tie will then be transferred to their adopters. So again, the relationship, the legal tie between the biological parent will cease and will be transferred to the adopter. So that is the general rule. However, if the adopter is a biological parent of the adoptee, then that legal tie is not severed, but the parental authority will be exercised both by the biological parent and the husband or wife of the adoptee. So, what if, through some really bad circumstance, what if the adopter dies? What will happen to the adoptee? So, this was discussed in the case of Bartolome versus SSS. So, on that particular case, the court ruled that if the adoptee is still a minor or incapacitated and his adopter dies, parental authority reverts back to the biological parent. So, in this particular case, the court actually admitted that there is no express provision in the law saying what will happen in case the adopter dies. So, what they use is the rule on rescission, which will be discussed by Arian later. But the gist of that rule is the tie between the adopter and the adoptee, which was severed because of death, will be reverted to the biological parent. So the reason that the court gave is, since the state has a policy of protecting the best interest of the child, it will be against the best interest of the child if that child or if that adoptee would be left without no means of support. Because if the adopter dies and he will not receive support from them anymore, it will then be beneficial to him or her and logical that he or she will be then again within the parental authority of his or her biological parent. Okay. So again, when it comes to the effect of parental authority, is that when there is adoption, it will be transferred to the adopter, the adoptee, except if it is a biological parent. And if the adopter dies, parental authority will revert back to the biological parent. So those are the important concepts here in transfer of parental authority. The next effect is legitimacy. So as we mentioned in the transfer of parental authority, the legal tie is then transferred to the adopter and the adoptee. And that also entails the benefits of legitimacy. So adoption endows the adoptee with a legitimate status for all intents and purposes. So our classmates discussed earlier on the benefits of the legitimacy. So all of those benefits will then now be enjoyed by the adoptee upon being adopted. Okay. However, the relationship established by the adoption is limited to the adopters only, except as provided by law. So why is this relevant? Because when it comes to the fruits of or the benefits of legitimacy, the particular legitimacy is only enjoyed by the adopter themselves and the adoptee. It doesn't extend to the brothers, the ascendants, or the descendants of the adopter. So for example, if I am adopted and the parents of my adopter died, I will not automatically be an heir to their parents or my adoptive grandparents. That is the general rule. However, if I have blood relationship with my adopter, that my adoption will give me legitimacy not only through my personal relationship with my adopter, but it would also extend to the ascendants, descendants, brothers and sisters. So that means that if someone, if they die, I will be one of the heirs. Is that clear? Thank you. Thank you. So, again, we will now try to look deeper into the right to use the adopter surname and the right to support. Because, again, as was mentioned earlier, one of the benefits of legitimacy also includes the right to use the adopter surname and the right to support. But when it comes here to the right to use the adopter surname, we should keep in mind that there are cases in which, even though the adopters are a married couple, that doesn't necessarily follow that I will automatically follow the surname of the father or of the husband. There are certain cases in which that I will only follow the surname of the mother or the wife. What are those cases? Because before, the law did not make it mandatory the joint filing of adoption. So there are cases in which only the wife actually filed the adoption and the husband only consented to the adoption. So the law says that even if the husband actually gave consent, it doesn't mean that he is one of the adopters. Hence, my relationship with the adopter is only through the one that actually adopted me. So in that example that I mentioned, I am only the adopted son of the wife. So that will follow that my right as a legitimate son of the wife will only exist on that particular relationship because he is the only one that adopted me, not the husband. So that is one of the limitations. Another example given by Atty. Rabuya in his book is that when adoption happens during legal separation. So I'm not that quite sure what will happen. Kasi normally if they are legally separated, they will still have the same name, di ba? But I guess if there are instances that the wife will only use her maiden name, then if she adopted me during legal separation, I will only use her surname, not the surname of her husband. And another important thing about the use of the adopter's surname is that when the adopter adopts you before he or she is married. And so since you were adopted before the marriage, and again, we need to remember that adoption will only have a personal tie between you and the adopter. So that means that if your adopter is not yet married, you will only use his or her surname. So subsequent marriage of your adopter will not entitle you to the use of his or her husband's or wife's surname. So yan yung isa pang importante. And then there's also this interesting case in the book because this only pertains to the mostly they will only want to use the surname of the father. What if the case is I want to use the surname of my mother as my middle name? Does the law allow that? So in the book, I think that if I'm not mistaken, the case is about regarding the adoption of Stephanie Astorga Garcia. In a particular case, the law says that the court ruled that there is no specific provision that disallows the adoptee to use the surname of his or her natural mother. So if we connect that to the concept that the state will always act in the best interest of the child, then the court ruled that let her use it. Let them use it. Since there is no express law prohibiting it, why not? So that is the precedent when it comes to using the surname of the mother as her middle name. So next, effective legitimacy is the right to support. So again, it will all boil down to the legal tie between the adopter and the adoptee. So because there is that tie, they are entitled to, you are required to give support to your adoptee. Okay? And then it would beg the question, so does that mean that I don't have the right or the benefit to ask for support from my biological parents? So again, between the biological parents and your adopted parents. So the law is clear. When it comes to adopted parents, of course you will get support because you have already been legitimized. However, when it comes to your biological parents, the law actually, through the Domestic Adoption Act, it says that since the tie between you and your biological parent has already been severed, it also means that you are not entitled anymore to receive support from them. So those are the important matters about legitimacy. So next is the effect on succession. So again, it would all be connected to the concept that your legal tie between your biological parent been severed, and then your legal tie with your adopter is established. So doon din po iikot si succession. So adoptee becomes a compulsory heir of the adopter, again, because of the established legal tie, because of the legitimacy. Next, the adopter and adoptee become legal heirs of each other in intestate succession. Again, this is one of the benefits of being a legitimate child. And again, you will connect it to the concept of the cessation of the connection to the biological and the establishment of the connection to the adopter. Again, the same effect when it comes to your biological parent. Kasi in the original provision, in Article 108, paragraph 3, it says that you being adopted will not disbar you from actually succeeding your biological parents, even if you're already adopted. However, that has already been impliedly repealed by the subsequent laws about adoption that were passed by law. So again, in this case, adoptee and the biological parents cease to have reciprocal rights of succession. That is the general rule. However, if there is a provision in the will that you are being given a part or a share in the inheritance, that would stand. So again, when it comes to succession between your biological parent, the general rule is you will not be an heir anymore, except if it is provided in the will. So that is the in summary and in as fast a manner as I can, those are the effects of adoption. Thank you, and I will now turn you over to Ariane to discuss rescission of adoption.
So I'm Ariane Grace Abed, and I will be talking about the rescission of adoption. So most cases of adoption have a happy ending. The adoptive parents usually or previously childless have or find peace and joy in having a child or finally having a complete family. On the other hand, the adoptive child or the child finds peace, security, and identity, and finally able to have a new family. So in some cases where the adoptive parents did not have enough time to bond with the child, the relationship turns problematic. When the adoptive parents want to get out of the adoption, the question is, can they still revoke it? Unfortunately, Philippine law says that the adoptive parents can no longer revoke the adoption. This is because of the Republic Act, RA number 8554, also known as the Domestic Adoption Act, which took effect on March 22, 1998. And this new statute deleted the right of the adopters to rescind the decree of adoption. Under Section 19 of Article 6 of Republic Act number 8552, it states that grants for rescission of adoption or upon petition of the adopter with the assistance of the department, if a minor or if over 18 years of age but is incapacitated, as guardians are cancelled, the adoption may be rescinded on any of the following grounds committed by the adopters. So what are the grounds for rescission of adoption? First is maltreatment. It should be verbal or physical maltreatment by the adopters. It should also be continuous and repetitive. So it is stated that the adopted is entitled to have a wholesome family or removed from a destructive environment. Next is attempt on life or criminal attempt, which endangers the life of the adoptee and contravenes the purpose of adoption, which is to provide the adoptee with a family environment that will ensure a productive life on the part of the adoptee. Next is sexual assault or violence. It proves that the adopter does not deserve to continue acting as the adoptive parent because it is highly detrimental and could cause psychological trauma, which could affect the character and the mental well-being of the child. Lastly is abandonment. It is the willful and deliberate act of foregoing all parental duties. which directly negates the purpose of adoption. So what can the adopters do since the adoption being in the best interest of the child, adopters cannot rescind adoption. So under the second paragraph of Section 19 of the Domestic Adoption Act, it provides that adoption being in the best interest of the child shall not be subject to rescission by the adopters. However, the adopters may disinherit the adoptee for causes provided in Article 919 of the Civil Code. So, in some instance, like upon the grounds recognized by law, an adopter may deny to an adopted child his legitimacy by will and testament, may freely exclude him from having a share in the disposable portion of his estate. So, since unfair naman sa adoptive parents, kung wala na silang right to revoke the adoption, ang sabi ng state natin, pwede nilang i-disinherit yung adoptive child nila. So, pwede nilang hindi pamanahan yung adoptive child. So, however, if the adopter files for disinheritance and there is a subsequent reconciliation between the adopter and the adoptee, it deprives the right of the adopter of the right to disinherit and renders any disinheritance made ineffective. So, if the petition is granted, what are the effects of rescission? The first effect of rescission is the parental authority restored to biological parent if known. So, if ever kilala nung bata or nung adoptive child yung parents niya or buhay pa, yung parental authority ay mare-restore sa biological parents niya. If not, if hindi kilala naman yung biological parents, the legal custody of the child will be restored to the DSWD. Next, there is reciprocal rights and obligations between adopter and adoptee is extinguished. Next, civil registrar to amend certificate of birth to original state. So yung civil registry, ibabalik nila yung original state nung birth certificate ng bata. So, babalik siya sa una niyang apelido gamit yung surname nung kanyang biological parents. Next, succession rights reverted to prior to adoption. However, vested rights acquired prior to judicial rescission shall be respected. These effects shall be without prejudice to the imposable penalties under the Penal Code of the Criminal Acts are properly proven. So, under the grounds for rescission of adoption, let us take into consideration that only the adoptee has the legal standing since sabi nga sa RA number 8552, only the adoptee can revoke or rescind the adoption since hindi na nga pwedeng adoptive parents, ang pwede lang nilang gawin is to disinherit the child. So, what are the prescriptive period? The adoptee, if incapacitated, must file the petition for rescission or revocation of the adoption within 5 years after he reaches the age of majority, which is 18 years old. Or if he was incompetent at the time of the adoption within 5 years after recovery from such incompetency. So, yun lang. Next topic will be discussed by Ren Support.
So I am Renalyn Pinion. I welcome you, Ren. I will discuss the concept of support until when the support between spouses ceases. So support, as stated in Article 194 of the Family Code, support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. So support may include the necessities and luxuries that is entitled to a person for him, that is entitled to be enjoyed, and to have by a person. So the education of the person entitled to be supported shall include the schooling or training, and for the transportation shall include the expense in going to and from school and going to and from place of work. So for support, as given the meaning from the book that applies only to means of subsistence during life, given that context, the following are not in the essence of the meaning of the word support. However, the duty and right to arrange the funeral of a relative is included in accordance on the order established for support. So Article 195. Subject to the provisions of the succeeding articles, the following are obliged to support each other to the whole extent set forth in the preceding article. So the spouses are obligated to support each other. Since here, the meaning of spouses is the legal wife and the legal husband, and which in the marriage imposes the right to right to support each other. So another is under Article 195, legitimate ascendants and descendants. Here, the support, the basis of support here is the legitimacy of the relationship between the ascendants and descendants. So So parents and their legitimate children and the legitimate children of the latter, parents and their illegitimate children and the legitimate children of the latter, legitimate brothers and sisters, whether of full or half blood. So here, what we can conclude is that parents, even though he is an illegitimate father or mother, is obliged to support his child, even though the parental authority is being exercised by the mother. Here we take note that the inventre de sa mere, wherein the direct translation is in the belly of his mother or in the mother's womb. Meaning, the unborn child has the right to support from its progenitors or from its parents, even though the child is still on the belly of the mother. Article 196. Brothers and sisters not legitimately related. So, you can read the provisions on our civil code, but what do we need to take note on this particular provision is that the term not legitimately related. And that the support for the not legitimately related brothers and sisters ceases when there is the cause for support arises due to a cause imputable to the claimant's fault or death. Article 197. So in case of legitimate ascendants, descendants, whether legitimate or illegitimate and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person. So basically, Article 197 describes the answerable property for support. So I will just summarize it. So the answerable property for the support of spouse, common children, and legitimate children of either spouse is that the support can be dischargeable from the absolute community of property and from the conjugal partnership of gains. However, in case of insufficiency or unpaid balance, the spouses solidarity with their separate properties, the support will be deducted from the said properties. So for the support of illegitimate children and support of legitimate ascendants, descendants, and siblings, this can also be, the general rule for this is that the separate property of the obliged spouse shall be answerable for the support of the illegitimate and legitimate ascendants, descendants, and siblings. However, if in case of insufficiency, it can be chargeable to the absolute community of property or conjugal partnership of gains. However, it is again of insufficiency in both ACP or CPG. the the support will be derived from the liquidation from the community from the liquidation of the absolute community property of the obliged spouse or the liquidation of the conjugal partnership of the obliged spouse. So here, Article 198, this article particularly states the when does the mutual support of the spouses ceases. So here, it ceases when the final judgment granting the petition, the obligation of mutual support between the spouses, has been granted. Or in case of legal separation, even though the marriage ban was not severed, the obligation for mutual support shall cease. And the court may have its discretion to order the guilty spouse to give support to the innocent one. So that's it. So for the next part, we will discuss by end.
Hi, my name is Eric Gumandable, and I will discuss you the indemnity line, the order of liability, and the amount of support. First, let us discuss what is pendente line. So, pendente line is a Latin term which means awaiting litigation. So, support pendente line between spouses is the financial support given by the spouses during the pendency of action for annulment, declaration of nullity, and legal separation. So, ano ba yung basis? Ayon sa nasusulat, according to Article 49.62 of the Family Code of the Philippines, during the pendency of an action for annulment, declaration of nullity of marriage, legal separation, the court shall provide the support of the spouses and the children. The reason is the utmost consideration given by the state to the welfare and more moral and maternal of the children. The support shall come, of course, sa ACP and CPG. So, please take note that under Article 198, upon the declaration of the nullity of the marriage, the obligation to support and the right to be supported ceases. So, since support is a burden to the husband, it is just na meron siyang defense kung ayaw niya mag-support. So, one of the defense is the denial of marriage, since yung support, ang ties niya is kung meron ba talagang marriage na nangyari. So, if one of the parties of the marriage allege that there is no marriage, so to speak, so that is a valid defense. And number 2 is committing adultery. So, when the wife commits adultery, it is only logical that the husband cut his support to his wife. Kasi, niloko na siya eh. Ba't mo masusuportahan? Okay.
Hug kita.
So, the
Naramdaman mo
next is
naman.
the procedure. I will not discuss it one by one since you can read it in the book. So what is common among the procedure is the beneficiary can ask the employer of the husband to directly deduct from their salary. So Article 199 and Article 200 discuss the order of liability for support. So Article 199, it states here the hierarchy of support. So this article states that a rich brother cannot be compelled to give support if the parents is capable of giving support. So hindi mo pwede pilitin yung brother na mag-support kung kaya naman ng tatay nila. May hierarchy tayo. Tatay muna. So, Article 200 naman, it states na kung marami yung pwedeng mag-support. So, here, yung beneficiary can claim, as a general rule, pwede niya i-claim sa lahat. Pero,
without prejudice dun sa right nung nagbigay na i-claim din yung proportionate portion na dun sa ibang obligor. So, at magkano ba itong pinag-uusapan nating support? According to law, walang specific amount na binibigay ang korte. Depende yan sa maraming factors. Such as, yung capacity ng magbibigay. Yun. And the next topic will be discussed by Marvin. Thank you.